We have previously discussed about the Industrial Disputes Act. There you may remember that we are referring to collective agreements and the legal authority capacity of such agreements. We can consider collective agreements as an opportunity to indicate the legal authority in this sector. This Gratuity Act is a factor connected to collective agreements. This has been included as a bonus in the collective agreement in 1983 and has then got implemented through an act in Parliament. This applies to the workers who become eligible under the Gratuity Payment Act No. 12 of 1983. Let's now look at the requirements to be fulfilled to get entitled for gratuity payments as per this act. A number of 15 or more workers should be employed in the relevant institution during the period of 12 months from the date of determination of employment by a worker. A number of 15 or more workers should have been employed in the relevant institution during the period of 12 months from the date of termination of employment by a worker, and similarly, a continuous service period of 5 years should have been completed. The worker should have completed a service period of 5 years. No need areas for the worker to fill any application to obtain the gratuity payments, and the employee is entitled to settle the gratuity payments within a period of 1 month from the resignation or the termination of service. You don't need to fill any application in order to get your gratuity payment. The employee is entitled to settle the gratuity payments within a period of 1 month from the resignation or the termination of service. In a situation where a certain employee defaults the payment of gratuity, a complaint can be lodged at the Labour Office of the area under the purview of which your working place is located. You have the capacity to complain at the Labour Office of the area under the purview of which your working place is located in a situation where a certain employee defaults the payment of gratuity. In case of death, a certain worker, the amount of money to be paid under the gratuity fund shall be paid to the family members of the deceased. In case of the death of a certain worker, the family members of the deceased are entitled to the amount of money to be paid on the gratuity fund. What are the parties which are not covered under the Act? Who are the workers that do not get any coverage under this? Domestic workers, place where the numbers of workers is less than 15, workers who have not completed a service period of 5 years. The parties that are not covered under this Act are the domestic workers, workers working in places where the numbers of workers is less than 15, and the workers who have not completed a service period of 5 years, therefore, with regard to the payment of gratuity. The fact whether the worker is appointed on permanent, temporary, manpower or contract basis does not matter here. With regard to the payment of gratuity, no attention is paid to whether the worker has been appointed on permanent, temporary, manpower or contract basis. Similarly, the working have an appointment letter or not having it has no relevance here. A person who has been summoned to work under a verbal agreement too is entitled to get the gratuity payment. With regard to gratuity payments, it does not matter whether the worker has received an appointment letter or not. Even a person summoned verbally is entitled for gratuity payment. The final salary drawn by the worker is considered for gratuity payment. Similarly, it's the last drawn salary of the worker which is considered at calculating the gratuity. If the worker is entitled to pension, which is non-contributory from his salary, such workers are not entitled. If the worker is getting a present which is non-contributory from the worker's salary, there is no entitlement for gratuity. It does not matter whether the worker possesses a letter of appointment or not. Even though the person has been summoned to work verbally, he can get entitled by submitting salary slips, attendance sheets, signature sheets for receipts of the letters sent to him or her as evidence to show that he or she has been employed for 5 years. Here, there should be an unbroken service period of 5 years. The salary slips, attendance sheets, signature sheets for receiving the copies of letters sent by the company can be considered as evidence. Thank you. Social space. This is your space. Your protection is your right. Please join with us to reach to the latest information on Socialist Face. Subscribe us. Press the bell icon too.